Picture a busy intersection. It's the middle of the day. You have the squeal of tires, the crunch of metal on metal, a classic T-bone collision. Now, usually when we look at a car accident, our instinct as human beings is to immediately look for the villain. We want to know who caused this, who is the bad guy.
Right. We're wired to look for the primary fault. We want a clear narrative, a victim and a perpetrator.
Exactly. And in the case we're breaking down today, Massengale v. Pitts, the bad guy, seems pretty obvious at first glance. You have a driver, Marteel Pitts, who makes a left turn right across oncoming traffic. The other driver, Minda Massengale, she had the green light. It seems open and shut. But then you zoom in on Massengale, the supposed victim here. She's speeding. She's not wearing her legally required glasses. And just to add another layer, she is actively praying while driving.
It really does sound like a law school exam hypothetical. Something designed to, make students just pull their hair out. Too many variables.
But it's a real case. And this case from the District of Columbia Court of Appeals in 1999 brings us face to face with a legal doctrine that feels, frankly, incredibly harsh. Contributory negligence. So the big question we're wrestling with today isn't just who caused the crash, but in a world where both drivers mess up, who pays?
And in the jurisdiction we're talking about today, Washington, D.C., the answer is often shocking. It's nobody.
That is a terrifying thought for anyone who drives a car. So let's get into the machinery of this. What's our mission for this deep dive?
Our mission is to really dissect the doctrine of contributory negligence. It's a concept that's totally different from what most people know as comparative negligence. We need to understand how a plaintiff's own bad behavior can essentially nuke their entire lawsuit. We have a specific roadmap. First, we'll break down the general rule of contributory negligence. Then second, we'll look at the presumption of negligence, what happens when you break a traffic law, like forgetting your glasses. Third, we have to talk about the favored driver doctrine, which, it destroys the myth that a green light is some kind of safety shield. And finally, we'll do a strict step-by-step FIRAC analysis of the case itself before building a diagnostic checklist.
Okay, before we get into the weeds, give us the so what here. Why does this specific case matter so much?
The so what is that the District of Columbia is one of the very few pure contributory negligence jurisdictions left. Most of the U.S. uses comparative negligence, where if you're, say, 20% at fault, you just lose 20% of the money. In D.C., if the plaintiff is found to be even 1% at fault, it can be complete bar to recovery. It's all or nothing.
That raises the stakes immensely. It means your own conduct has to be practically spotless to win a lawsuit there. Let's start with the basics then. Concept 1, the general rule. What is the actual black-letter definition of contributory negligence?
Okay, so to assert this defense, the defendant, the person being sued, has the burden of proof. They have to prove two things by a preponderance of the evidence, which is just legalese for more likely than not. First, that the plaintiff failed to exercise reasonable care, and second, that this failure was a substantial factor in causing the injury.
You want to drill down on that second part. Substantial factor sounds a bit subjective. What's the legal standard for that?
The court looks to another case for that. It's an act that plays a significant part in bringing about the injury. It doesn't have to be the only cause, or even the main cause. It just has to be a real player in the chain of events.
So you have to be careless, and that carelessness has to actually matter. If I'm driving without my glasses, but I get rear-ended while stopped at a red light, my vision didn't cause that crash.
Precisely. There has to be that causal link. Negligence in the air, so to speak, doesn't count.
Okay, let's pivot. Concept 2, the presumption of negligence. This is where the Massengale case gets really sticky. We have a driver ignoring a restriction on her license. How does the law handle that?
This brings us to the rule of presumption. The court explains that if you violate a traffic regulation, a statute designed for safety, the law presumes you're being negligent. You don't start at neutral. You start in the negative.
That's a heavy burden. Is that presumption absolute? I mean, does breaking a rule mean you automatically lose?
No, it's not absolute. It is rebuttable. But the bar to rebut it is incredibly high. You have to show that you did all a reasonable person who wished to comply with the law would do.
Wish to comply. That's interesting phrasing.
It is. It implies real effort. You have to prove you were trying your best. For example, if your glasses just broke and you were driving cautiously to get them fixed, you might have an argument. But if you just decided not to wear them, you're probably out of luck.
That makes sense. Okay, let's look at concept 3. Massengale, the plaintiff here, had a green light. I think most of us assume a green light means you're safe, you're the king of the road. So if I have a green light, am I automatically shielded from liability?
You would think so, wouldn't you? It's the common intuition.
Mm-hmm.
But the law says no. This is the limiting rule for the favored driver. A favored driver, the one with the green light, still has a duty to maintain a proper lookout when entering an intersection.
So a green light isn't a force field.
Not at all. A green light is not permission to close your eyes. If you fail to look, and that failure is a substantial factor in the crash, you're contributorily negligent. You have to anticipate that other drivers might do something reckless.
That's a crucial distinction. It basically writes defensive driving into the legal code. Before we apply all this to the case, I want us to feel the full weight of this. You said DC is an all-or-nothing jurisdiction. Can you illustrate just how severe that is?
Let's use a visceral hypothetical. Imagine a defendant is clearly and egregiously negligent. Let's say he's drunk, runs a red light, speeding. He's 99% responsible for all the danger.
Okay, so the defendant is absolutely the villain. We want him to pay.
Right. But now imagine the plaintiff is just slightly negligent. Maybe she looked down at the radio for a split second, or, like in our case, wasn't wearing her required glasses. Under the pure contributory negligence rule in D.C., that tiny 1% bit of negligence is a complete bar to recovery.
So wait, even if the defendant caused 99% of the problem, and the plaintiff only contributed 1%.
The plaintiff gets $0. Nothing. The lawsuit is dismissed. It's a brutal, brutal outcome. The old logic is that the law won't aid someone who helped cause their own injury, no matter how slightly.
That feels archaic. It feels like the law is just ignoring the huge disparity in fault. But that's the playing field. With that context, let's dive into Massengale v. Pitts. First, what are the legally dispositive facts?
Okay, here's the scene. Minda Massengale, the plaintiff, is driving eastbound. Martial Pitts, the defendant, is westbound and wants to turn left across her lane. Now, Massengale had a license restriction requiring corrective glasses, but, and this is the hinge, she wasn't wearing them.
Okay, strike one.
Strike two, she admitted to praying while driving, and the evidence suggests she was moving quickly. She did, however, enter the intersection on a green light. Now, the defendant, Pitts, he actually saw Massengale coming. He saw her from about 4 or 5 car lengths away.
Wait, he saw her and he turned anyway?
Yes. He initiated his left turn right into her path.
Okay, so Pitts definitely messed up. That sounds like the 99% negligence we just talked about. He saw oncoming traffic and turned in front of it.
Correct. In almost any other state, Pitts pays. But here is the smoking gun fact that changes everything for Massengale. There was a cab driver in the lane right next to her, moving at the same speed.
Why does the cab driver matter?
Because the cab driver acts as a control variable, a baseline for a reasonable person. When Pitts started that turn, the cabbie saw the danger. He hit his brakes, stopped, put the car in reverse, and avoided the crash. He reacted. Massengale did not.
That cab driver is going to be really important for the causation part. So based on those facts, what was the core legal issue?
The issue is really narrow. Did the trial court make a mistake in finding the plaintiff, Massengale, contributorily negligent? Basically, was it wrong to bar her from recovery when Pitts was so obviously at fault?
And what rule of law did the court apply? Please state the full rule and break it down into its testable elements for us.
The court applied the rule of contributory negligence. As we discussed, the defense has to prove 2 distinct elements. Element 1 is breach of duty. Did the plaintiff fail to exercise reasonable care? And element 2 is causation. Was that failure a substantial factor in causing the accident?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the failure to exercise reasonable care?
Okay, let's do a mini IRAC for that first element. The sub-rule here is that violating a DC traffic regulation, in this case, driving without complying with license restrictions, creates that presumption of negligence we talked about earlier.
And the application to Massengale.
It was a pretty straightforward application. Massengale admitted she wasn't wearing her glasses. That violated the statute. So, boom, the presumption of negligence is established right there. She then offered no evidence at all to rebut it. She didn't say they were lost or broken. She just wasn't wearing them. Plus, the court noted the praying and moving quickly as other signs of a lack of focus.
So the finding on element 1 is a slam dunk. She was negligent.
Yes. But negligence in a vacuum doesn't matter. It has to be connected to the crash. Which brings us to element 2.
Understood. Now, what about the second element? Was this a substantial factor? This seems harder to prove. She had the green light. Pitts turned right in front of her. How can her not wearing glasses be a substantial factor?
This is where the court gets surgical. Let's do the mini IRAC for element 2. The sub-rule is that a favored driver, even with a green light, must maintain a proper lookout. If avoiding the accident was possible with due care, and you failed to do so, your failure is a substantial factor.
And this is where the cab driver comes back into play.
Exactly. This is the application.
Hmm?
The court directly compared Massengale to the cab driver. They were in the same position at the same speed. The cabbie saw Pitts, stopped, reversed, and avoided the crash. This proved empirically that the accident was avoidable.
That is just damning evidence. If the cabbie hadn't been there, she could have argued it happened so fast no one could have stopped.
Precisely. Without the cabbie, her argument is much stronger. But he proved that with due care, meaning looking out the window and reacting, a crash didn't have to happen. Therefore, the court concluded her failure to see Pitts, who was visible from 4 to 5 car lengths away, and her failure to brake were substantial factors. She didn't react because she either didn't see clearly or just wasn't paying attention.
So the finding on element 2.
The finding was that the causation element was met. Her negligence played a substantial part in the collision.
And after analyzing all the elements, what was the court's final conclusion?
The Court of Appeals affirmed the trial court's decision. Because D.C. is a pure contributory negligence jurisdiction, Massengale's own negligence acts as a complete bar to recovery. She gets 0 damages. Pitts, despite his reckless turn, walks away without paying her a dime.
Wow, it really emphasizes how technical the law can be. It's not about fairness in the common sense of the word, it's about adherence to duty. Okay, let's zoom out. If a listener encounters a similar situation on an exam or in real life, how should they approach it? Can you distill this whole thing into a diagnostic checklist?
Absolutely. If you see a messy accident in a place like D.C., you should run this step-by-step diagnostic checklist. Step 1 is the statutory check. Did the plaintiff violate a safety rule? Speeding, missing glasses, texting. If yes, you immediately have a presumption of negligence. Step 2 is the rebuttal check. Did the plaintiff do everything a reasonable person wishing to comply would do? If the answer is no, then the breach is established. Step 3 is the favored driver trap. Even if the plaintiff had the right of way like a green light, did they fail to keep a proper lookout? Did they just assume the road was theirs? Step 4 is what I call the cab driver test. This is your causation test. Ask, could a reasonable person in the same spot have avoided the crash? If a witness did avoid it, the answer is a clear yes. That makes the plaintiff's failure a substantial factor. And finally, step 5 is the jurisdiction check. Is this D.C., Maryland, Virginia, or Alabama? If it's one of those, it's contributory negligence, step P. The recovery is barred completely.
That checklist is gold, especially the cab driver test. It's such a concrete way to think about causation. It really makes you wonder, though, how would this case have ended if that cab driver just hadn't been there that day?
It's a fascinating thought. Without that witness proving the crash was avoidable, Massengale might have actually won. It just shows how legal liability can hang on these tiny, specific, factual details. Like who just happens to be driving in the lane next to you.
A real sliding doors moment. And I suppose a reminder to all of us, the green light is not a guarantee.
And if your license says must wear glasses, please, for everyone's sake, wear your glasses.
Amen to that. Thanks for listening to this deep dive. Drive safe, keep your eyes open, and we'll see you on the next one.